Good evening, ladies and gentlemen. My name is Paul Lucas. I'm the Queensland President of the Institute of International Affairs, and welcome here tonight at Holding Redlick. I would like to also welcome people online. I would like to acknowledge traditional owners of the land on which we meet tonight and acknowledge elders past, present and emerging. Now we have a wonderful speaker tonight. Our first talk for the year, in a year where we've got a lot of speakers locked in already. Typical to AIIAQ, they're very varied but always interesting. But our speaker tonight, who it's a great pleasure for me to introduce on his topic of strengthening judicial services in the Pacific, is the Honourable Paul Judicial. And I just wanted to say a little bit about Paul and tell you a little bit about him. Of course, he is a former Governor of Queensland, 2014 to 2021, a former Chief Justice of Queensland, 1998 to 2014. But that isn't just all he has done. He's been a Chancellor of the Anglican Archdiocese of Brisbane. He has just recently appointed a Legal Aid Commissioner. He's chaired the Law Reform Commission. He was appointed himself at a very young age. I've had the privilege of dealing, and of course, relevantly to tonight, he's a judge in appeal for the Kingdom of Tonga. I've had the pleasure of dealing with Paul in a number of different capacities over a very long time. The first one would have been as a lawyer, and you probably wouldn't have noticed me much in those days because I was a pretty junior lawyer before I got into Parliament. But certainly then subsequently as a minister and an attorney, as Attorney General, and then as Governor, Paul was a wonderful person to deal with in terms of obviously his first-class knowledge of the appropriateness of separation of powers and the doctrine in each of the roles to be performed, but a terribly courteous and effective Chief Justice, and what I would say as well, and a Governor who was very keen to be a Governor for all of Queensland. What always particularly impressed me about him as a Chief Justice, though, was his absolute determination, notwithstanding that he was a very eminent appeal judge, to sit in trials as often as he could and to sit in trials in some very, very remote, challenging circumstances rather than just sit in Brisbane in air conditioning. So that's all I'm going to say about Paul, other than the fact that he is a first-class speaker and frankly a first-class human being. But his talk tonight will speak for itself. After that, our Vice President and someone who knows a little bit himself about the Pacific, Raymond He, will convene a question and answer session with the judge. Over to you, Paul.
Thank you, Mr. President. Ladies and gentlemen, I'm very pleased to have the opportunity this evening to speak a little about the Australian and, in fact, New Zealand contribution to the judicial systems of our developing friends in the Pacific. As you've heard, my small foray has concerned the Kingdom of Tonga, and I will come to that. But first, I acknowledge the traditional custodians of these lands, the Turrbal and Yagara people, and express my respect for their elders, past, present, and to come. This sort of contribution of which I'm speaking this evening has been going on for a long time. I recall when I joined our Supreme Court here in 1985, its judges had been sitting in the Supreme Court of the Solomon Islands in Honiara for many years. I think that thrust was begun by Mr. Justice Peter Connolly, as judges were then known, and he was followed by, again, Mr. Justice Bruce McPherson, and then, times having changed, Justice Glenn Williams. It was, I understand, a voluntary commitment, and though no doubt adjustments were made as necessary to their calendars at home. So there was an altruistic essence to it. There is no doubt that the experience and knowledge and expertise of those judges enriched the local jurisprudence. It was educative. for a much less, if I may say, sophisticated local profession. When I visited the court in Honiara when I was Chief Justice, that court was so bereft of material resources that it could not even afford to purchase stationery. As to PMG, the Queensland Bar regularly runs workshops in Port Moresby for the PNG Bar, and our bar is to be congratulated for that. For some years, from the Federal Court of Australia, centred here in Brisbane, Justice John Logan and Justice Berna Collier have regularly sat in PNG. And on the stipulation, as I understand it, that they will not be asked to impose the death penalty. When I was Chief Justice, we had a fairly close relationship with the Supreme Court of PNG, providing administrative support and advice, which was welcomed. They greatly appreciated our giving them little things to us, like audio recording equipment, of which they were in desperate need in their courts. They weren't fazed by the circumstance that it was surplus to our own requirements here. Otherwise, it would have been consigned to a basement to deteriorate and gather dust. We also, somewhat oddly, gave them lecterns for the bar tables in the courtrooms, to which barristers could cling when anxious. I can speak from personal experience. But mainly retired judges from Australia and New Zealand serve as needed in many Pacific jurisdictions, especially Fiji. There have been some political issues there over the years. The Cook Islands, Samoa, and Pitcairn Island, of bounty fame and sexual depredation infamy. I was very excited in one of my trips to Tonga to meet the judge who presided over those trials at Pitcairn Island. Very difficult to get in and out of. Those jurisdictions have legal systems very similar to ours. The Sir Samuel Griffith Criminal Code, which originated in Queensland, has migrated to many of them, indeed to many parts of the world. Judges who sit in those jurisdictions from Australia and New Zealand are always very concerned to respect the mores of the locals. Even a hint of patronage would mean that they were not invited back. One's being there depends very much on being invited. Which brings me back to Tonga, where I was appointed for 3 years, from the 28th of July 2022. I had finished up as governor after 7 years plus on the 1st of November 2021. Now, I have in my 76-year lifetime only had to submit to 3 job interviews. The first was in the mid to late 1960s, when I sought a job with the ring crew at the RNA Eka. The boys, they were only boys, who put up the railings for the sheepdog trials and so on. The interview was brief, and notwithstanding my then puny frame, I got the job. The next step was to join the AWU. I kept my union ticket proudly for many years, but when prior to being sworn in as governor, the Courier Mail asked me for some interesting exhibits from my past, I just couldn't find them.
Luckily.
I'm not sure about that. Paper. The second job interview was when the then Attorney General, Denver Beanland, interviewed me very gently, prior to my appointment as Chief Justice in 1998. He was interested in how I would approach the role, collegiality, etc. And he also interviewed my wife, Kay. That government was very keen on having a Chief Justice and partner who worked together with the profession and especially in the regions. Which brings me, ladies and gentlemen, to the third interview, which preceded the Tongan appointment. The panel comprised the Lord Chief Justice of the Kingdom of Tonga, a senior counsel from Melbourne, who lived, however, for his 5-year term full-time in Nuku'alofa, the capital city. There was also a Privy Councillor, yes, they have a Privy Councillor in Tonga, a Privy Councillor, the Right Honourable Lord Dalgety QC, who hailed from Scotland. His peerage was of Tongan origin. The Lord Chief Justice said to me, it was a Zoom hearing, towards the end of the hearing, now that you have left Government House, you must be inundated with invitations. We are concerned, he said, to be assured that you would be available when required. I think I somewhat confounded him by answering that when you leave Government House, the invitations immediately dry up completely. And that's the way it should be. The guard has changed. Then there was the swearing in, again by Zoom. The Tongans, you know, are intensely religious people. The oath of loyalty I took to King Tupou VI was not expressed as here to be an oath by Almighty God, but it says, I swear in the presence of God, etc. And the officials, I might say, were astute to ensure that you held a Bible, not as maybe apocryphally in a regional Queensland courthouse once, where a Bible could not be located and a juror took the oath on a copy of Uncle Tom's Cabin. When I have been in the capital, Nuku'alofa, the other judges of appeal and I have attended the Wesleyan Methodist Church on Sunday mornings. The congregation includes many hundreds of locals in their Sunday best, and very often the King and Queen and their grandchildren. The royals sit in an elevated gallery at the side of the church. Incidentally, the King's daughter, a royal princess, is the Tongan High Commissioner in Australia. We judges, our main interest has been in the singing. We cannot follow the liturgy because it's all in Tongan. But the singing, accompanied by a brass band, is truly up there. The kingdom is a constitutional monarchy, the only one in the Pacific. It is very dependent on external aid. I suspect some of that comes from China. They give us a car and driver when we are there, 2 fortnightly sittings a year, and the giveaway for me was noting instructions on the car door as to opening it and so forth in Chinese script. The nation has been subjected to serious disruption. Massive damage a few years ago from a major tsunami following a major underwater volcano. Much of that damage still unrepaired. They just can't afford it. Don't have the person power to take it in hand. The lack of resources has meant that a lot of the younger men from Tonga come to work in Australia where they can earn proper money, which I imagine they repatriate. While by no means well off, impoverished really, the people are universally friendly and of good cheer, save for the some exceptions we see in the courthouse. Much of the population is employed in the public service, which I imagine survives on that external aid money. Most of the rest lead subsistence existences, selling fruit and vegetables at roadside stalls and second-hand clothing. I should perhaps have mentioned earlier that though it comprises 176 islands, only about 36 are inhabited. The population is just over 100,000. I think I was most recently told 115,000. So it is a tiny kingdom. But it presents, nevertheless, with all the confidence of the great Westminster traditions. Land ownership is feudal in nature. The lords own the land and cede it by lease or license to the locals. There is the usual executive, legislative and judicial division. There was substantial change following public outcry in 2010, with the King ceding many powers to the Cabinet. The Court of Appeal hears a great variety of cases, constitutional, criminal and civil. The process is necessarily cumbersome, for the proceedings in the lower courts are conducted in Tongan, and the evidence for the Court of Appeal has to be translated into English, a laborious and expensive process. But the court staff go about their tasks with good humour, and I get the distinct impression that the nation greatly appreciates the involvement of we Australian and New Zealand judges and former judges. The most dramatic constitutional case with which I was involved was a challenge to a no-confidence motion in the Prime Minister. As you know, courts are loath to intervene in the affairs of the duly elected Parliament. And fortunately, in that case, for us, legislative standards had simply not been reached. My first sittings, urgently by Zoom, concerned challenges to elections at a general election. Most of the claims were of bribery, Tongan style. Will you vote for me if I give you a box of frozen chicken? Or $50 of that ilk. Other cases raised more difficult issues of equitable estoppel, for example. The Lord let me live on this land and knew I was enhancing it by construction, but then denied my capacity to sell it as my own. I speak briefly, but some of these cases raised quite difficult issues. All determinations of the Tongan Court of Appeal are reported online through PACLI, so there is building up a body of jurisprudence which will help those coming through. And I earnestly hope that develops into a confidence in due course to appoint a Tongan as Chief Justice. The current Chief Justice of Tonga comes from the UK. There is immense reassurance in having one of one's own as head of the judiciary, and I believe that Tonga has that talent and capacity. There is another curiosity about our involvement in Tonga. I have always been of the view The judges in their judgments are constrained by the submissions made to them in court. Judges trespass beyond that at their peril because they have not had the benefit of reasoned submissions from the parties. In other words, it is up to the parties to define the landscape, and judges should not go outside the limits they set. While this generally still obtains in the Court of Appeal in Tonga, we judges of appeal are sometimes more expansive in our reasons than we would be over here. In doing that from time to time, we are moved, I think, by a realisation that the opportunities for legal education of the local profession are limited. Though again, the Queensland Bar is doing its best to help. And also that notwithstanding the internet, access to legal materials is more limited. Another curiosity, which I mentioned in conversation earlier, is that the Tongan appellate model is that the Court of Appeal generally comprises on its panel 4 sitting judges, not 3 as here. Here we sit 3 judges on the basis that if there is dissent by one judge, there will be a result thanks to the other 2, who in that case are termed the majority. The majority will agree on the result, if not necessarily the reason. In my limited experience in Tonga, the 4 judges have always agreed, and there has always been a joint judgment with no dissent. That does not mean that these judgments are not reached after enthusiastic debate among the judges. A further feature of the Tongan appellate system is timeliness. There is inevitably delay because the Court of Appeal generally sits only twice a year. But when the court does sit, it sits for 2 consecutive weeks at a time. The first of oral hearings and the second writing and delivering the judgments. Of course, a lot of preparatory work is done at home before the sittings, to which the printer in my study can attest. But the extraordinary Australian judicial delay in delivery of judgment is not a feature in Tonga. I'm very proud of it. I've always been very critical of Australian courts for their delay, which I brand as a species of judicial arrogance. I hope you found this interesting, ladies and gentlemen. Joining the Tonga Court of Appeal has been a most diverting aspect of my retirement. Grueling for an older person. A full day there, a full day back, and lots of reading. One doesn't do this for material reward. One does it, frankly, to help out jurisdictions which cry out for support. It is a privilege to have these opportunities, and as I have said, my distinct feeling is that this support is greatly appreciated. I admire the willingness and expertise of my fellow Australians to accept the rightness of the aid program to less fortunate communities. The legal profession, which embraces the serving and retired judiciaries, plays an important role in all this. This is just another instance of the devotion to public service, which the profession rightly reminds its members of, a devotion which should characterise our approach. As I have said, the Queensland practising profession plays its important part, and I'm pleased that the retired judges are doing the same. Now, I've been somewhat repetitious, for which I apologise, especially on the public duty, which has always been important to me. It reminds me of my early governorship We held formal dinners regularly to thank significant Queensland contributors and to encourage others. Government House would prepare remarks for me to be delivered at the table. For the first couple of dinners, I dutifully read the script, but then imperiously, I thought, no, I should be expected to speak without a script. From the heart, as they say. I did so, and afterwards I asked the official secretary, who was at the dinner, what he thought. Well, he said, you said all the right things. The only trouble was that you said them 7 times over and the soup got cold. Thank you.